we have a wonderful example where obviously one country has been extremely successful in a way influencing the regulators to have a very good model which helps in a way to sustain it. I don't want to introduce Andrew too long because I think a lot of you know him pretty well. Andrew has been with the Asian Racing Federation as Secretary General, but moreover, he was the Chief Executive of the ARB, Australian Racing Board, and we are very happy that we could, not for financial reasons, but for further development reasons, could convince him to come to Hong Kong and with the Secretariat. So with any further ado, I would like to hand over this to Andrew. Thank you.
Thank you, Winfried. Louis, your comments this morning about the cost of speakers last year reminds me of that story of the fellow who's invited by his alma mater to come back and make an address to the leaving year. He does that, and he's feeling very pleased with himself, and then the school bursar comes up and presents a cheque for his travel costs, and he's on such a high, he waves it away. No, that won't be at all necessary. And the bursar brightens considerably, and he said, "Oh, that's great," he said, "we can put that money aside and get a better speaker next year." Good afternoon, delegates. I've been asked to look at the role that intellectual property rights might be able to play in achieving a fair return to racing from wagering. I start with these two propositions. First, establishing clear property rights protection for the wagering contingencies which are created by the organisers of horse races would contribute materially towards achieving a fair business environment for racing to operate within. And second, if a fair business environment does not exist, then the value which racing generates for the community and for governments will be materially affected. Simply described, intellectual property rights are rights to exclude others from exploiting a non-tangible asset. In economic terms, the international intellectual property rights system, founded on the Paris and Berne Conventions in the late 19th century, has been calibrated to achieve a balance between legal incentives to create and the public interest in free competition. The exclusive rights framework which this system establishes is justified in economic theory as providing creators with an economic incentive to create. Such a framework ensures that the creator of intellectual property is able to reap the fruits of his investment in creating that property, giving him the necessary incentive to make the requisite investment. Without this framework, a free market would result in underproduction, which is not Pareto optimal. Government intervention in the form of the property rights system is justified as a means of avoiding that market failure from occurring. The need for some form of property rights protection so as to provide incentives to create is especially acute in the case of some public goods. Public goods have the following properties. They are non-rivalrous and non-excludable. Those who benefit from a good or service without contributing to its creation are termed free riders. In an unregulated market, free riding can result in public goods being underprovided. The outcome of a race has the characteristics of a public good. It's non-rivalrous, and the number of bets can be placed on a given outcome without reducing availability. It's also non-exclusable. It's difficult for a race organiser to prevent individuals from placing bets on the races they provide. This highlights racing's dilemma. The industry's major source of revenue is wagering, and to stimulate that wagering, race organisers disseminate as widely as possible all of the information necessary to place a bet, including race fields, scratchings, broadcasts and race results. However, once this information is disclosed to the world, then, provided that there is more than one operator operating in the market, individuals can place their bets with any operator, irrespective of whether that entity has the race organiser's permission, without reimbursing it for the costs of production. Accordingly, the first question is to ask whether the existing intellectual property rights laws afford racing with the requisite protection against free riding by wagering operators. In our circumstances, the starting point must be to understand that facts and information are not copyrightable. The legal authorities make this clear. This principle is also enunciated in the International Agreement on Trade-Related Aspects of Intellectual Property Rights, negotiated at the conclusion of the Uruguay round. To bring itself within the protection of copyright law, the race organiser must first establish that it is the author of an original work of authorship or a literary work. If we look at a sample of countries, compilations or lists of factual information may be so viewed, but the tests which are applied vary markedly around the world. A number of jurisdictions have set the threshold at a low level. For example, the UK courts have held that copyright protection is given as a reward for the author's investment of time or money, even if there is no creativity in that work. This has been labelled the sweat of the brow doctrine. Support for this doctrine has also been given by the New Zealand and the Hong Kong courts. However, in the US, the courts have set a high bar. Originality is the key requirement, and this requires creativity in the selection or arrangement. The Australian courts have moved decisively in the same direction since 2009. The relevance of all this to racing is this. Where the sweat of the brow doctrine is an accepted part of a country's jurisprudence, then it should be relatively easy for racing to establish that copyright subsists in its race fields. However, where the sweat of the brow doctrine has been repudiated, the job will be much harder. It will be necessary to show the creative spark that is involved in the creation and ultimate expression of race fields. If a racing organiser did elect to employ copyright law as a means of dealing with unauthorised wagering, then there are a number of practical steps it would need to take to place itself in a position to do this. 1, catalogue the process involved in the production of race fields, from nominations and acceptances right through to publication. 2, ensure that all those individuals who are involved in producing the race fields are employees of the racing organisation or have made a written assignment of their copyright to the organiser. 3, identify the racing authority's claim to copyright. Copyright notices should be attached to all copyrightable materials at every point of publication or distribution, from the calendar and race program to race books and form guides published in newspapers. An example of such a notice appears on this slide. 4, extract written acknowledgement of copyright from all third parties that are supplied with racing information. Finally, assume for the moment that copyright does subsist in a race card and that the race organiser has taken all of the steps that I've outlined. The next issue will be whether the wagering operator has infringed that copyright. For infringement to take place, the operator must have reproduced a substantial part of the race card. 2 relevant considerations here are these. First is this: use and reproduction are 2 very different things. A cake recipe in a cookbook that's copied in another book may be an infringement of copyright, but merely using the recipe, that is, following its instructions to bake a cake, is not. In our circumstances, if a wagering operator does no more than take bets over the telephone without reproducing the race field, for example on a website, then there's no reproduction and hence no infringement. Second consideration is this: when determining whether a substantial part of a compilation has been reproduced, the quantity and quality of what has been copied must be considered. The US authorities say that the copyright protection given to compilations is thin, that is, something approaching wholesale reproduction is needed to constitute infringement. Reproducing slivers of information will not. Therefore, reproducing on a website a list of all horses and weights in the same order as the race field produced by the race organiser, but leaving out some small part of the other information, could reasonably be argued to be reproducing a substantial part of the copyright work. What's most difficult to predict is the court's likely attitude in a scenario where the wagering operator has constructed his site reproducing only a scant amount of the information published by the racing organiser, as for example in the race field to the right of the slide. I turn now to the sui generis database right. The 1980s ushered in the information age. This digital and telecommunications revolution carried with it a fundamental challenge to an intellectual property rights system developed for the era of the print media. Commencing in the 1990s, the European Commission began to examine the legal status of databases, especially electronic databases, in the process of formulating an overall strategy for information technologies, which ultimately found expression in the Database Directive. Addressing the issue of free riding was inherent to the policy objectives of this move. There are 2 tiers to the Database Directive. The first tier is the establishment of an entirely new intellectual property right for the creators of databases. The sui generis database right is set out in Article 7.1 of the Database Directive. On the face of it, this was the perfect remedy for sporting organisations afflicted by betting operators using their lists of sporting events, fixtures, without authorisation. It is sweat of the brow type protection. The test is substantial investment in the obtaining, verification or presentation of the database contents. Both UK racing and English and Scottish Premier League football moved swiftly to claim that companies which were using their data for the purposes of taking bets on football matches, on races or football matches, infringed this new IPR. In British Horse Racing Board and William Hill, the UK's national racing industry body led evidence about the resources it invested in organising horse races, including the resources expended in deciding the date, the time, the place and the name of the race, the runners in that race, the weights to be carried, and so on. These were all contents of a database it maintained. However, the European Court of Justice ruled that investment in obtaining the contents of a database refers to resources used to seek out existing materials and collect them in the database. It does not cover the resources used for the creation of materials which make up the contents of a database. The BHP's investment in organising horse races, etc., was investment in the creation of the material contained in that database. The BHP also invested resources in verification, verifying the identity of the horse, its nominator, the jockey. But this also took place at the stage of creation. The court furthermore held that William Hill had not extracted or utilised a substantial part of the database. Luxembourg had well and truly torpedoed the hopes of racing and sport to use the sui generis IPR as a remedy against free riding. Some commentators have interpreted these decisions as a conscious policy move by the court to prevent the creation of monopoly power. Interestingly, when the European Commission published its first evaluation of whether the Database Directive has been successful in achieving its goals, it concluded that the court's restrictive construction in these cases went against the Commission's original intention. The report also noted the damage done by the court's judgments to the funding plans envisaged by sports bodies. However, 9 years have elapsed since the court's judgments, and there have been no moves made to amend the Database Directive to give the sui generis database right a broader application. The second tier of the Database Directive is to create a European-wide copyright in databases. This is contained in Article 3.1 of the Database Directive. The first thing to note about the harmonised database copyright law is that the UK and Ireland, which have applied the lower threshold of originality for copyright to subsist in a compilation, were required by the Database Directive to lift the bar in the case of copyright protection for databases. But how high has the bar now been set? While the sui generis database right generated considerable litigation on its proper interpretation, remarkably, the European Court of Justice's judgment in the Football Data Co against Yahoo case, handed down in March of this year, was the first instance of the court giving some interpretation of this second tier. Football Data Co is the company set up by the football leagues in England and Scotland to licence and sell the contents of their fixtures list. Football Data Co claimed infringement of a number of IPRs, including copyright in the fixture list as an original database. It led detailed evidence on the complex and time-consuming process involved in creating the fixture lists. A frisson of hope was sparked when Justice Floyd J, the judge at first instance, found in Football Data Co's favour on this ground. He said that the selection or arrangement required by Article 3 is not confined to selection or arrangement formed after the data is finally created. I quote, "To cut out from consideration these selection decisions merely because they occur whilst the database is being created seems to me to be arbitrary and conceptually fraught with difficulty." End of quote. This decision at first instance was extremely encouraging. However, the English Court of Appeal was not necessarily convinced. It referred a number of questions to the European Court of Justice, which in March this year it dispiritingly answered in terms as restrictive as its decision in the BHP case. The matter has now gone back to the English Court of Appeal for it to assess, on the evidence it has before it, whether the selection or arrangement of the data contained in the fixture lists amounts to an original expression of creative freedom of its author. Plainly, it's to be hoped from our point of view that the Court of Appeal so finds, but it is difficult to be sanguine. In the late 1990s and the first years of the new century, much of what passed for policy development proposals concerning the Australian wagering market consisted of how to cosset the TABs from any competition in the off-course market. For example, senior TAB executives continually urged racing administrators to reinstate the ban on racegoers using their mobile phones when they came to the track. But technology makes ring-fencing a market a difficult exercise. Where legal guarantees of free trade and competition exist, it's an impossible one. The approach taken by the Australian Racing Board was to instead strike out for the middle ground, and a submission was made to the Council of Australian Racing Ministers calling for the introduction of a product fee payable by all wagering operators. Once support for this principle was established, the ARB followed through with a proposal that all state and territories introduce racefields legislation. The ARB's strongest selling point for the racefields concept was that it positively embraced the plural operator wagering market which already existed in Australia, but dealt with free riding by criminalising evasion of the obligation to remunerate racing. All were welcome, but all must pay. An important refinement of the legislation came about as a consequence of an early legal challenge. In Tom and Bill Waterhouse against Racing New South Wales, the plaintiff successfully argued that he was not required to obtain a racefields approval because it was not part of his business operation to publish a board for horses racing in New South Wales. It was true that in operating the bookmaker's computer system, his staff would enter a list of each racefield, but there was no public access to this system, and the Supreme Court held that publishing, in the sense used in the legislation, was a communication to the world at large. This led to the racefields legislation being amended with its fulcrum switched from publishing to use, and use is defined in extremely broad terms. This legislation and its administrative application was the subject of challenges brought by two wagering operators. Both challenges relied on the guarantee provided by Section 92 of the Australian Constitution that trade, commerce and intercourse among the states shall be absolutely free. As Mr Duffy has indicated, the High Court dismissed both challenges, 7-0 decisions. One important feature of the legislation is its territorial reach. In the New South Wales legislation, the offence is use in Australia or elsewhere of specified information. Plainly, while the law extends to wagering operators not based in Australia, actually prosecuting one is another matter. A request by Australia for the extradition of a person from another country in relation to an offence against a law of Australia can only be made by or with the authority of the Attorney-General. Extradition requests are only made in respect of offences the maximum penalty for which is not less than 12 months. This requirement is met here. A further requirement is dual criminality. That is, the conduct constituting the extradition offence, either in total or in part, must be criminalised in both the requested state and the requesting state. Plainly, this condition cannot currently be met in our circumstances. However, the criminal offence feature of the racefields legislation is still capable of having an effect on the behaviour of non-Australian based operators. Individuals face the prospect of prosecution if they ever step onto Australian soil, and corporations whose shares are publicly traded are likely to give some thought to the reputational implications of doing acts which constitute criminal offences in another country whose legal system is generally held in good regard internationally. In terms of a continuum, racefields legislation is most potent when the wagering operator is based and or licensed in the jurisdiction. However, as the slide illustrates, there are degrees of effectiveness in other circumstances. It should be noted that in the Australian context, the racefields legislation was only able to survive legal challenge because operators other than the TAB were genuinely able to obtain approval to use racefields. The racefields legislation which Western Australia first enacted was struck down by the High Court because the approval system for non-WA wagering operators was found to be illusory. In Europe, Article 102 of the Treaty on the Functioning of the European Union provides a check on the abuse of a dominant position in a market. In the McGill case, the European Court of Justice held that refusal to licence use of the defendant's copyright-protected materials lists of television programs amounted to an abuse of a dominant position. So far as Europe is concerned, it is interesting to consider whether any question arises of EU members being prevented from enacting race fields legislation by the Database Directive to the extent that it precludes national legislation which grants databases copyright conditions which are different to those set out in Article 3.1. In Australia, race fields legislation is not part of the copyright law. Would the European Court of Justice look at form or substance if race fields legislation was enacted in one of the EU member states? Finally, it should be noted that there may be broader implications from race fields legislation. Already, other sporting organisations in Australia are looking to the possibility of similar legislation being enacted. In the final analysis, these observations may be made. One, the sui generis database right is a dead letter for racing. Two, in the EU, the scope for copyright to be used as a weapon against free riding will become much clearer once the English Court of Appeal hands down its decision in Football Data Co against Yahoo. Three, outside Europe, the scope for copyright to be used against free riding wagering operators potentially exists, but the tests applied vary around the world. Four, comparing copyright with race fields, the use of copyright protection where that is available has certain deficits, but nevertheless, it should not be discounted as a strategy. Looking to the future, I suggest for the Federation's consideration these 4 steps. 1. Each country's racing authority present here today can consider the longer paper from which this presentation has been drawn and decide if they wish to explore this area further. 2. Those racing authorities would then scope the particular issues that exist in their countries which might be addressed by an IPR or race fields strategy. 3. This could then lead to the Federation's Executive Council developing one or more templates, for example, model race fields legislation. And 4, and finally, the International Federation could then have a continuing role in advocating the adoption of these templates by your respective governments. Thank you very much.